Singapore, a gay Singaporean man traveled to the United States and paid $200,000 to father a boy through surrogacy arrangements. A district judge has rejected his bid to adopt the child, now 4 years old, whom he brought back with him to Singapore. The Adoption of Children Act did not envisage the specific situation this case presents, the court said. The Singaporean man, a doctor, has been in a gay relationship with a partner here for 13 years. Some years back, they approached the Ministry of Social and Family Development to inquire about the possibility of adopting a child. They were told that the ministry was unlikely to recommend adoption of children by a homosexual couple. The man then traveled to the U.S. where his sperm was used to impregnate the egg of an anonymous donor, using in vitro fertilization, IVF, procedures. The embryo was then transplanted into the womb of another woman, who offered to carry it to term for $200,000. As the biological father of the child, the Singaporean was allowed to bring the child back here to live with him. He started adoption proceedings to legitimize his relationship with the child, the court heard. His application has been turned down by District Judge Chopin Air. In judgment grounds released on Tuesday, December 26, she pointed out that as a doctor, the man was fully aware that Singapore does not condone surrogacy, in which a woman agrees to carry to term a child who is not her own, usually for a fee. Also, the use of IVF is confined to married couples, under Singapore law. Having carried out the procedure in the U.S., the man now wanted Singapore courts to sanction the adoption by pointing to the welfare of the child principle, the judge said. She said the applicant, being a doctor, was acutely aware that the medical procedures undertaken to have a child of his own would not have been possible in Singapore. He cannot then come to the courts of the very same jurisdiction to have the acts condoned. The applicant's lawyers Koh Tien Hua, Yvonne Chong and Sean Ho denied that he was seeking to adopt the child so as to form a lawfully recognized family unit with his partner, in effect a gay family. Judge Nair was not swayed by the arguments. This application is in reality an attempt to obtain a desired result, that is, formalizing the parent-child relationship in order to obtain certain benefits such as citizenship rights, by walking through the back door of the system when the front door was firmly shut. Then, there was the issue of a large sum of money being paid to the surrogate mother. The very idea of a biological father seeking to adopt a child after paying a surrogate mother a sum of $200,000 to carry his child to term reflects the very thing the Adoption Act seeks to prevent, the use of money to encourage the movement of life from one hand to another, said Judge Nair. The welfare of the child was not the issue either in this case, as he would continue to get a roof over his head, food on his table and a good support system, with or without an adoption order. The applicant is the only parent he knows.